So, welcome everybody. Welcome here in The Hague. So early afternoon, but as well end of the afternoon in Kathmandu, in Nepal. So today we have a match. Actually, this is a match of this group because you were three teams, but now you are only two. So this is the match actually between two teams in order to decide which team will finish first of this group, and as well determining as well your adverse team for the eighth of finals. So today we have the Catholic University of Lille, Université catholique de Lille, and as well Kathmandu University, so two teams. And before starting, just to remind that yes, this match is important for the eighth of finals afterwards, but as well it's important as well for networking as well. So this is a match organized by the Corax Foundation for the Hague Inter-University Law Debate Tournament 2022, and the topic that you got today was common adoption of hybrid work requires no change in current labor law practice. So this is the topic you got for the last 10 days to prepare, and today we'll hear about your argumentation as well, the different positions. So what I could tell is that at this moment we have the three members concerning Kathmandu University, and we'll have as well obviously the third member connecting as well for Lille, but we can already start a little bit to have some introduction, and of course we'll wait for the third one as well from Lille. Miss Pradhan, could you introduce yourself maybe?
Sure. Greetings, everyone. My name is Vastika Pradhan. I'm a fourth-year law student at Kathmandu University School of Law. This is my first time partaking in an international law debate tournament. I'm very excited. The practice debate matches were really well, and I'm expecting really well-thought arguments from the opposition. I'm really looking forward to the debate.
Thank you very much. Miss Pelacia?
Good afternoon. So I am Laetitia Pelacia. I am a student at the University Catholique de Lille in France. I am in Master 1 International and European Law, and I hope to do next year a specialization in international human rights law. And we are also really excited to exchange with you, and especially knowing that you are so far away, and it's all of it makes it even more interesting. So we are really looking forward to it. Thank you.
Thank you. Miss Diksha Dital.
Hey everyone, my name is Diksha Dital. I'm from Kathmandu University School of Law. I'm in my final year at law school, and given our previous experience at the friendly matches also, debating has been really exciting, and I've learned a lot through the practice debates as well. So I'm looking forward to this debate.
Thank you. Miss Héloïse André.
Hello, so I'm Eloise. I'm also in the Université Catholique of Lille with Laetitia, and I'm also in my Master 1 of International and European Law. And I'm very excited to do this debate with you, the other team. As Laetitia says, it feels so exciting that you guys are kind of so far away from us. So it's very exciting. And we're excited to just see the arguments from you guys. And yeah, that's it.
Thank you very much. Miss Asmita Pandey.
Hello everyone, I'm Asmita, and I'm also in my final year of law school, and I'm currently studying corporate law. And yeah, I'm really excited about the debate too.
And I see that Miss Polycarp is just joining exactly at the moment.
Sorry for being late.
No, that's perfect.
I had an internet problem. I'm really sorry.
No, that's okay. Could you maybe introduce yourself? We are just doing the introduction at this moment. Yes? Your microphone. Yes. No. Yes.
I'm sorry I didn't hear what you said.
Yes, could you introduce yourself?
Yes, so I'm Andrew Polycarp. I come from the university. The Catholic University of Lille. I'm in the first year, so I'm very pleased to participate in this debate.
Thank you very much. So now that we have both teams complete and ready for the match, so I will share my screen in order to draw the positions, and afterwards you'll have the 5 minutes of preparation to review your notes based on the positions that you get in a few seconds. So I will share my screen, and you will see the wheel spinning a little bit. So just to explain, there are two possibilities for each team. So two possibilities, it means you could be in favor, you could be against, and then I will click here in order to know which position you will have. So for that debate, that will be Lille will be in favor, and that will be Kathmandu will be against. So it means the common adoption of hybrid work requires no change, so that is actually the position defended by Lille for that match, and Kathmandu will defend that the common adoption of hybrid work requires change in the current labor law. So I want to mention one element indeed that my colleague was mentioning in message to me, which is that this topic has been proposed by one of the main sponsors of this competition with Absolute Internship, who provides internship actually to the students who are interested to do an internship in, all organized in a different country. This is the reason as well why they propose this topic, because hybrid is part of as well working in an internship format. So we thank as well, of course, Absolute Internship for their support, because without them it would have been extremely difficult as well to organize this competition. So this topic is coming from our sponsors, and now you have 5 minutes.
The 5 minutes is starting now.
Okay, time is up for the preparation. So now you can all open your camera and we'll start the debate match. So as I mentioned earlier, this will be Catholic University of Lille will be starting with the introductory speech, with the opening statement. So I would like to give the floor to Lille for the opening speech. You have 4 minutes.
Before starting, could you please make sure that I'm audible and visible, please?
Yes, you are.
Thank you. Dear jury, dear colleagues of the Kathmandu University, thank you for being here today. I am Amber Polycarp, and I will be pleading on behalf of the arguments. As such, I will sustain that the common adoption of hybrid work requires no change in the current labor law practice. Our first argument is that states have recently improved or created legislations around remote work. We can acknowledge that there's been a lack of law framework for a long time surrounding that topic. However, thanks to the pandemic, states have realized that there was a need to put legislation to protect the workers, their rights, and provide for healthy work-life balance. In fact, why should we change the current labor law practice when the change has already been done? COVID-19 has highlighted how little regulation there is around hybrid work. Indeed, at an European level, this practice was only regulated by the FRA directive, an other directive relating to working conditions and occupational safety and health. But these directives were applied to every type of work, but none of them were really specifically about remote working. In fact, it was the state's responsibility and competence to create such legislation. The issue being put forward, countries have responded by creating countless legislation on that topic in the past few years. By March 2021, 5 new countries have implemented legal change regarding that topic: Spain, Slovakia, Luxembourg, and even Latvia. Furthermore, many other countries have been reviewing their national legislation on the topic, such as Austria, Belgium, Cyprus, Croatia, Hungary, or even Germany. The Netherlands, for example, have adopted the Flexible Working Act, and Ireland, the National Remote Work Strategy in January 2021. My second argument is that not only new legislation have been put forward, but it has been created to perfectly ensure workers' rights and freedom, as well as a healthy environment for the workers. Indeed, these changes to national regulations concerning telework are focusing on its conditions, such as duration and frequency of the teleworking, the right to disconnect during periods of rest, and the ability to ensure a healthy work-life balance while teleworking. Most of the new regulations also imply provision, including the responsibility of the employer to ensure that the teleworking station is ergonomic and helps to prevent the development of aggravation of physical issues. For example, the Royal Decree law taking place in Spain reinforced the employee's right to disconnect and strengthen the workers' rights when it comes to the ergonomic, psychosocial, and organizational aspects of teleworking. Because of this decree, Spanish employers are now obliged to carry out risk assessments of the workers' teleworking place. This shows that workers moving to hybrid work are as much protected than usual workers. In the United States, all employers must support federal, state, and local regulations surrounding that topic to their teleworkers, like the Equal Employment Opportunity within the Family and Medical Leave Act. The topic saw this posting goes from minimum wage to fair employment to human trafficking. These postings are mandatory and are made to make sure that the remote worker is aware that he has access to his rights and he is protected by the law. Can we still say that the current labor law practice should be changing when it is already protecting so many people and their working conditions? Thank you.
Thank you very much. So now I will give the floor to Kathmandu University for your opening statement. You have 4 minutes as well.
Thank you. Distinguished judges and esteemed colleagues from the University of Lille, I am Osmita Pandey, the first speaker for the opposition, and I'll be opposing the motion. The common adoption of hybrid work requires no changes in current labor law practice. And I'll be doing so by illustrating my three arguments. Firstly, the novel concepts that need to be recognized in our post-pandemic world have not yet been recognized as such in our current labor practice. And due to this non-recognition, the problems faced by workers have been increased by manyfold. And thirdly, how we need an international standard and not just a European or Western standard for protection of their rights. So I'd like to start with a quote by the director of ILO Conditions of Work and Equality Department. She says that a law on telework and the right to disconnect is a point of departure, not of arrival. This illustrates how effectiveness of law and clear regulatory mechanisms are necessary to protect the right of workers. So I'd like to illustrate my first argument, which is that in our evolving world and in the world post-pandemic, there has been a need for new regulations due to the different conditions that have been resulted. We are over-connected, and there's this culture of always being connected and always being on culture, and this has created a digital obesity, which is having detrimental effects on workers who especially work remotely, because employers expect them to be on and available constantly, and this violates many workers' rights and labor standards. Eurofound data on 2021 shows that teleworkers are twice as likely to exceed the 48-hour working time limit, and also they have insufficient work in their free time and have many physical and mental health aspects. And to review these problems and to manage these changes, a right to disconnect has been proposed in many parliaments in Europe, as also illustrated by the Speaker of the Opposition. And however, this right to disconnect has only been acknowledged by a few parliaments and a few governments in the European states, and this has not been implemented by ILO itself or in any Eastern country or South Asian country per se. So these novel concepts that need to be recognized by all workers around the world are essential to be established as international legal standards and not just regional legal standards to protect workers all around the world. Further, I'd like to move to my second point, which illustrates the perils of current legal framework and if it goes on, what might we face going forward. The post-pandemic world needs to be aware of these problems because they have only been exacerbated by the pandemic. Firstly, I'd like to talk about a study and a brief published by WHO and ILO in 2021, which reported that without proper planning and organization of health and safety and the impact of teleworking in the physical, mental health, and social well-being of workers is grossly affected. And this has also been corroborated by many other studies by independent researchers. Further, we also face a problem of gender disparity. Gender disparity has only increased due to the pandemic because women are already prone to many changes and many problems in the workplace, such as lack of informal support structures and being overlooked for promotion, which is only exaggerated by this lack of legislation and lack of regulation that we face today due to a lack of international adopted standard. Therefore, I'd like to also reiterate my point that current labor practice is only limited to national legislation, and a new international standard and a collective framework is essential to protect hybrid workers in all jurisdictions. Thank you.
Thank you very much. So now it is time to give the floor to Lille to the first rebuttal. So you will have 2 minutes for your first rebuttal. No, we don't hear you.
Can you all hear me now?
Yes, now, yes.
Okay, good. Okay, I will start my rebuttal now. So we want to respond to Kathmandu University by first mentioning that currently employers around the world are straddling a bridge between yesterday, when most employees at most companies were physically present at work, and tomorrow, when there is a vaccine or effective treatment, which will open the possibility of safe return to the traditional workplace. Yet, even when this happens, remote work will have earned a permanent place in the employment mix. We want to mention that hybrid work is not only about teleworking, but it is also about working at the office, and therefore there's already laws in place to allow for workers to do this hybrid work. So the state of affairs present right now are that there's two challenges: how to manage remote working condition amid the uncertainty of today, and how to prepare for and optimize the hybrid working models of tomorrow, in which fully in-person and remote work will be the two ends of a fluid spectrum of options. The former is a necessity and the latter is an opportunity. Hybrid work models done right will allow organizations to better recruit talent, achieve innovation, and create value for all stakeholders. And so we know that remote work does works. And according to the Boston Consulting Group in the US, which have exhaustively surveyed employers, employee, and HR directors since the start of the pandemic, 3/4 of the employees surveyed in Germany, India, and the US have transitioned to or remain remote during COVID-19 say that they're at least as productive in performing their individual tasks as they were before the pandemic struck. This fact shows that the hybrid method of working is much more effective, and that there is no need to implement new laws, because this is already the case and it has been working during the pandemic efficiently. Thank you.
Thank you very much. Now I give the floor back to Kathmandu University for your first rebuttal. You have 2 minutes.
Thank you for my esteemed colleague for her opinion, but I'd also like to disagree with it. Firstly, I'd like to point out that you are making a contradictory statement, because on the one hand, you are saying that yes, hybrid work is effective, it is good, and it should be promoted, but you are ignoring the impacts that the lack of legislation, that only focusing on telework and not focusing on the hybrid part of the spectrum illustrates. And this lack of legislation and this disparity has created many problems, such as extended work time and always being available to work, and it has eradicated the personal and professional life boundaries. And and we propose that there need to be changes to accommodate these kind of changes in the legislation. Further, the existing labor practice are not comprehensive enough to include everything and include the boundaries boundaries such as working hours and personal life and other psychological and social impacts on on the rich personal lives of workers. And just because the workers say that they are okay with returning to remote work does not and are as productive does not mean that productivity is not harming their personal life and is not impacting them in other ways. So yeah, I'd like to conclude my rebuttal. Thank you.
Thank you very much. So now I give the floor back to the University in Lille for the second rebuttal. You have 2 minutes.
We agree that the reality of work in the future is going to be hybrid work, is going to be this new way of functioning. But we also think that there are good reasons why many companies are excited about the mixed in-person and remote work, because there is currently systems in Europe that actually do work. Countries such as Norway or Denmark are already functioning in hybrid work structures, and they are doing so because there is a trust between their employees and the employers, and that's why it already works, and there's no need for an extra legislation or change in labor law practices, because there is this trust, and because employers and employees have such communication between them. And therefore, this hybrid work system is functioning without it needing any further legislation. Thank you.
Thank you very much. So now the floor is to Kathmandu University as well for the second rebuttal. You have 2 minutes.
I'd like to ensure that I'm audible and both visible first. Okay.
Yes.
Distinguished judges and my esteemed colleagues, my name is Swastika Pradhan, speaking as the second speaker of the debate, arguing against the motion, that is, common adoption of hybrid work requires changes in the current labor law practice. I'd like to start by expanding upon the third argument by my first speaker, which is the current labor law practice does not encompass hybrid work and thereby requires an international standard. International labor standards are developed to provide a global system of instruments addressing the issues faced by laborers through a social dialogue between ILO members, which include a tripartite representation. Such a standard for hybrid work is absent with outdated standards such as the Home Work Convention 1996 that does not encompass hybrid work within its scope. Under Article 1B, employees who occasionally work from home, as with a hybrid working situation, is not covered under the convention as home workers. Only people who permanently work from home are considered under the convention. Similarly, the EU Framework Agreement on Telework, while it does a better job of addressing these nuances, it fails to recognize the needs of a post-pandemic world, such as the right to disconnect and the right to telework, as mentioned by my first speaker. Therefore, the existing current labor law practices are not comprehensive enough to address the more nuanced problems of the post-pandemic world, such as longer working hours for teleworkers, the blur between the boundaries of working hours and personal life, the disproportionate responsibility on women to address work and family needs, and the psychosocial impacts with increased screen time and remote work. The proposition, while they highlight the advantages of remote work, it is also important to recognize the perils of remote work, of companies wanting to enforce hyper-surveillance measures, which necessitate a requirement for an international law which is more comprehensive. I'd like to end my speech. Thank you.
Thank you. Thank you very much. So now I give the floor to Lille. This is the conclusion time, so it means you have 2 minutes.
Before starting, could you please confirm that I am audible and visible, please?
Yes, you are.
Thank you. Thank you, dear colleagues from Kathmandu University, for your counter-arguments. We agree totally that the reality of hybrid work is synonym of future, but we must remain on our position and respectfully disagree that the common adoption of hybrid work requires no changes in practice in the current labor law. Our first argument was that we shall not change the current labor law practice as the change has already been done and legislation have already been assumed and implemented. Indeed, we used a list of EU countries that have responded by creating countless legislation in the past few years. And we also mentioned specifically the Netherlands that have adopted the Flexible Working Act, Ireland to the National Remote Work Strategy, and Slovakia through the amendment of its Labour Code 31. Our second argument remains that workers moving to hybrid work are as much protected than usual workers. We use the example of the Royal Decree Law taking place in Spain in order to sustain this argument. Finally, our third argument is still that no need to change, as the pandemic brought unique issues that have already been overcome. In conclusion, we are sustaining that there is no need to change the current labor law practice, as the change has already been done in the common adoption of hybrid work legislation. As a consequence, we are asking you, dear judges, to consider the counter-arguments used by our dear colleagues from Kathmandu University in the light of our pro-arguments. We thank you for your consideration.
Thank you very much. So now I give the floor as well to Kathmandu University for your conclusion. You have 2 minutes.
Thank you. I would like to first confirm if I'm audible and visible.
Yes, you are. Yeah.
Okay. Sorry. Thank you so much, esteemed colleagues, for your arguments. But I would like to suggest that the opposition has clearly failed to determine the contrast between the developed world and the developing world. They have given prominent examples of Western countries, but have failed to seriously consider the concerns of the global East South, global East South Asia, among others. So, as a final speaker from the opposition, I would like to firmly restate our stance that the common adoption of hybrid work does require changes in current labor law practice. Firstly, the hybrid work setting creates a problem of an increasing effect on the mental health and well-being of the workers, which we cannot ignore, as well as an evident growth in various forms of worker exploitation, gender disparity, due to the already fragile work-life balance of women in an unequal society. However, these novel concepts of labor practice have largely been absent in the current labor law standards. Secondly, the right to disconnect has not been incorporated in the existing labor laws. Going back to the claim proposed by my first speaker, novel concepts of labor practice and placing due importance on the right to disconnect of the employees have not been recognized by international labor standards. In fact, there are no employment standards or legislation on hours of work and overtime relating specifically to hybrid work and the right to disconnect for overworked remote employees. It is evident that the extent of hybrid work has exploded because of the pandemic and that it is the future, but the implementation of hybrid working practice requires clear hybrid working policies to outline the specific parameters of businesses' approach to hybrid working, and it reinforces, and with this we'd like to reinforce the notion that common adoption of hybrid work requires important changes in the current labor law practices. Thank you.
Thank you very much. So this is the end of the debate. So from now you are not assessed. So thank you to both teams. So now you can relax a little bit, and then we talk about your performance, in giving you the floor for us to know what you thought about your performance or the performance of the other team or your own team as well. Starting with Miss Pelaccia. So what did you think about your performance and the teams?
Thank you, Mr. Lorange. Actually, I have to say that I hoped personally to have the counter arguments, because I have been working a lot actually on teleworking and hybrid work myself for the university here, and I really hoped I could use all the arguments I've been working hard on on other papers, but apparently destiny made it differently. So sincerely, I was not that happy, because even if we had some legislation, I think my colleagues from the Kathmandu University were right. We were really focusing on the European aspect, but it's normal. We are in an international, and especially focusing on European law. And I have to say this was maybe a point that I would have done differently, maybe focusing on all the other countries, and I haven't thought about making this distinction. So thank you for making it clear. Next time I will consider really like a broader, in a more broader way, let's say, also my research from a legislative point of view. And I am still happy about my team, because we have done researches, we worked together, and they used everything we could to try to let's say, to save our position. So thank you, my team, and thank you, Kathmandu University.
Many thanks, thank you. Miss Pradhan.
I think the proposition was excellent. I got to revise the new changes that are occurring in Europe in terms of teleworking. So that was a really good refreshing for our knowledge as well. I think I agree with her as well. We had a hard time arguing for the motion because through the pandemic, we've also felt like a need for a change in the laws of Nepal as well, because our law does not recognize remote work. So thinking from the proposition was definitely a challenge for us, and it was such a fulfilling experience as well, preparing for the both sides. I love that we get to prepare from the both sides. And we're so glad that we had such a competent team, and we get to learn so much through a debate. So we had really a good time, and I'm very proud of my team as well.
Thank you very much. And now the floor as well to Miss André. What did you think about your performance and the teams in general?
So I agree with Letitia about I was much more prepared for the contra arguments, let's say. And so I was kind of caught off guard because I thought I don't know, I just thought we were gonna be chosen for the contra arguments, which was kind of bad to assume, I assume. But I thought that the Kathmandu team argued very well. They looked very professional. All their arguments were very clear and straightforward, and yeah, they were very well prepared. And as for my team, of course, they were amazing. They were all very well prepared, and I worked very, very well with them. So yeah, I enjoyed the debate very much so. So yep, thank you.
Thank you very much. Miss Dikshadital?
This was a very interesting debate. I enjoyed the debate thoroughly, and I'm glad that all of us sort of agree on the common ground that there is a requirement for new legislations that specifically address hybrid working situations. So I'm glad about that, and I had a really great time. Thank you.
Thank you very much. Miss Polycarp?
Yes, so as always, when we have a new subject, there is always a preferred side. Obviously, today it was the counter-arguments, but it was still fun, at least maybe fulfilling and interesting to look at arguments we wouldn't go for usually, but I found it very interesting. And regarding the preparation, as the debates are going, I find that it's a very different exercise from the intro to the rebuttal and the conclusion, and it's very interesting to allow yourself to do those different exercises and to see what you're good for and maybe less good at. But it's very fulfilling overall, and I'm very, very proud of my team, because even though the exercise and the topic especially, personally, I've never learned about labor law, so it was quite a thing. But I'm very proud of the rebuttal, the conclusion, and we did our best overall. So thank you very much for this experience.
Thank you very much. And Miss Asmita Pandey?
Yeah, it's quite funny how all of us were well prepared for the counter arguments, and none of us wanted to do the proposition. But yeah, even we faced the same problem, and it is hard coming up with arguments from the other side. And so I think that with regards to that, you guys did really well. And yeah, it was fun listening to the arguments that you proposed. And yeah, I'm very proud of my team for doing what they did.
Thank you very much. Now I would like to give the floor as well to the coach of Kathmandu University, Miss Shreya Yoshi.
It was very interesting to listen to both the sides. I'm Shreya Joshi. I'm a practicing lawyer, and as a victim of work from home, I fully supported the other side. And it was I felt that the debate went very fast because there was so much to learn from the proposition side, like what European countries are doing and about different conventions and all of that. And I think my team did very well, considering I was a bit panicked because we were preparing at the very last minute, and I was kind of scared that they would get the proposition side because I didn't feel comfortable in that side either. I think both the teams did perfectly considering the sides, but I still see that the time is so limited and there's just so much you can say, but so limited time. And in that limited time, every speaker have fulfilled their role. Good luck for next round. Thank you so much.
Thank you very much. So of course, if you want to write about what you have research on for this topic, it's possible as well to transform it into an article, which will not be assessed by the judge. They will be assessing only the oral part. But yes, indeed, so that is indeed, it needs a lot of research and content to cover everything, but you did extremely well already in the debate, that's what I can say. I would like to give the floor as well to Ms. Urbanova, maybe?
Thank you very much, and what a good job to both teams. Indeed, time is quite limited. In total, you have a very few minutes for each position, and the time doesn't transfer. And I believe both teams did a really good job in making their points across and highlighting the most important aspects of your arguments. Really good job. And if you would like, as my colleague said, if you'd like to expand a bit more on the topic, or perhaps even between the two teams to collaborate together on a piece, don't hesitate to reach out. We do have a publishing platform, so our editing team can work with you, and you can either agree and collaborate or to write individually the pieces. I personally enjoyed the debate very much and would also enjoy reading about it further. And perhaps side note, it was very exciting to hear specific countries mentioned and the subjects they did, and also the international view has been very interesting. So again, good job to both teams and very nice execution.
Yes, so well done, and again, you will receive in a few days the assessment from the free judge. That will come in your email box, and we'll publish obviously the results as well. So the next match for you will be for each team, but separately, the 8th of final, so that will be in May. So you will get information in advance, 10 days in advance, obviously. And as well, you will know around the end of April which team as well you will be having the match against, which will be from other groups. So the first or second best team of another group will be your opponent. And at that time, indeed, you will have another topic on another theme, which will be the theme of the 8th of finals. So thanks again. Yes, Mr. Benoit? Yeah.
Yes, I just perhaps wanted to give a bit of backstage information that we'll be also sharing in a newsletter. We are updating accompanying events, some of which consist of networking events, so keep an eye out. You'll be able to meet each other also outside of the match environment. Just a bit of backstage information there. And I believe we also had a question, informal, from one team for the other.
Yes, absolutely. Actually, I was really interested to go to Nepal, and I saw that to do what I wanted to do, one of the craziest airport is apparently in Nepal. It's not in Kathmandu, but in Leski. I'm not sure how do you call it?
It's Lukla? No? Lukla? Yeah.
Yeah, exactly. And I wanted to ask you if you know this airport and if it's safe enough, actually.
It's considered one of the dangerous airports in the world, but there have been a lot of flights coming and going to Lukla. So I think, and the place is really beautiful and it's amazing. A lot of people go there, even people from Nepal go there for vacations, for studies, for their community outreach programs. It's an amazingly beautiful place, and I would recommend that you go there.
Okay, thank you. I will try to get over the fact that it seems really dangerous, but thank you a lot.
To precise, is from Lukla that you go for work to the Mount Everest, right?
Yes.
Yes, you have to land in Lukla. Yeah, okay. Okay.
Exactly. Well. Yes. That would be the goal one day. I hope soon enough.
Okay.
Thank you again.
So you will meet as well as the free students as well on the way. Yeah. Mm-hmm. So thank you. Many thanks to both of you, and of course to the Nepalese team. Please come to France to visit Lille, to visit Paris as well, but to visit as well the other team during the next months or years, because I'm sure you'll be welcome as well. Yeah? So many thanks again. Wish you a rest of the day, a very good rest of the day, afternoon and evening, and we keep in touch, of course, for the next match. Thank you. Bye-bye.
Thank you so much.
Thank you.
Bye-bye.
Thank you very much.
Thank you. Bye.
Bye.
Bye.